Over these 2 days, we have a great lineup of expert speakers who will be sharing their rich knowledge and experience. By attending this webinar, we hope you leave inspired to further develop your organization's human rights risk management. Now, without further ado, let me invite Dr. Srikanya Jadeep, Secretary General at Government Pension Fund, to make the opening remarks. Over to you, Dr. Srikanya.
Thank you, Yuki. Could you hear me all right?
Yes.
Good. Okay. Good morning from Bangkok, ladies and gentlemen. To our esteemed co-hosts and distinguished contributors, I would like to begin by expressing my gratitude to Yuki of the UNDP FI and the Stock Exchange of Thailand for co-hosting this webinar. Speaking on behalf of GPF, we are delighted and humbled to be joined by leading global institutions, standard setters, and practitioners. This webinar marks our initial effort to establish a common ground for a Thailand framework on human rights considerations. As a preliminary, our objective is to set forth a framework for conducting human rights due diligence, as well as to produce a human rights heat map for Thailand. GPF acknowledges the significance of responsible investing practices and aim to become a globally recognized as a sustainable pension back-to-back with generating sufficient returns. It has long been a belief of ours that this goal can and must be pursued simultaneously. Our ambition, instead of integrating ESG factors as a group of sustainable factors, we aim to bring forward material factors one by one in compliance to the SDG goals. The first two factors that we internally agree on their materialities are human rights and climate change. To begin, we start with human rights, with the cooperation and support from UNDP FI and the Stock Exchange of Thailand. The objective of this initiative are as follows: to form a collaborative engagement in the recognition of human rights as a material ESG factors, as well as to create a platform that unites financial practitioners and institutional investors domestically and hopefully across Asia. To be able to conduct human rights due diligence by learning from frameworks of global standard setters, as well as from the experienced practitioner, to raise awareness on the issue of human rights for institutional investors, an entity we are investing in aiming to invest, to collaboratively produce human rights heat map for Thailand as a benchmark for our ambition to reduce the heat, to promote and endorse listed companies that are active in integrating human rights in their business value chain. And finally, to encourage the disclosure of human rights information in public communication, particularly in annual report. To facilitate this objective, the project constitutes of two main activities. As Yuki just mentioned, the webinar, which will be for 2 days, today's and the day after tomorrow. The webinar is a starting point, aiming to learn from standard setter as for today. And for the day after tomorrow, we expect to learn and share common ground of human rights risk management framework from listed company, and also to learn from ESG index developer. Next to the 2-day webinar, GPF and Stock Exchange of Thailand aim to co-organize meeting with listed company and investor in Thailand, aiming to understand their situation and conclude a common framework for human rights integration and co-develop human rights heat map for business sectors in Thailand. Our financial outcome is we agree on the common framework, and we have the first human rights heat map for business in Thailand. That would conclude my opening remark of our ambition. To end, I would like to thank all the contributors to this event, including the global standard setters, notably the United Nations Environment Programme Finance Initiative UNEP FI, the Stock Exchange of Thailand, Morgan Stanley Capital International, the United Nations Development Programme UNDP, OECD, PRI, Shoulder Investment Management Limited, the Nation Australia Bank, Kasikorn Bank, APG Management, the Thai Union and Chancery. Thank you, ladies and gentlemen. Yuki, the floor is yours.
Thank you, Dr. Surikanya. UNFFI applauds GPF's leadership in offering collaborative opportunities in human rights and ESG issues. I think collaboration is the most efficient way to improve human rights practices and ESG issues in general. And I hope today we will see a lot of that happening in practice, in action. So let's now start the first session. Before we start, I'd like to make another housekeeping announcement. So we have left some time for Q&A after each speaker, and we encourage you to ask questions or make comments using the Q&A function. So don't use the chat box, but please use the Q&A box, the Q&A function that is at the bottom of your Zoom platform. And we encourage you to be interactive and participate in this webinar with us. So now let's move on to the first session. The first session is the introduction on human rights. So in 2019, the Thai government published the National Action Plan on Business and Human Rights with the objective of disseminating the UN Guiding Principles on Business and Human Rights and encouraging its uptake amongst the Thai business community. This session will seek to answer introductory questions such as what are human rights and what are the UN Guiding Principles on Business and Human Rights, why it is important for businesses to respect human rights. Our distinguished speaker for this session is Dr. Harpreet Kaur, Business and Human Rights Specialist at UNDP in Asia and the Pacific. Harpreet has over 15 years of experience with a decade exclusively on business and human rights. Harpreet held various senior leadership and management positions, including at Ashoka University and the Business and Human Rights Resource Center. Harpreet joins us on her last day in quarantine in Bangkok, having moved from India. Congratulations on ending your quarantine today, Harpreet, and thank you very much for speaking with us on such a busy day. So Harpreet, the floor is yours.
Thanks, Yuki, and good morning, everyone. As Yuki said, this is my last day of quarantine, so couldn't be more happy. Couldn't be more happy today, but also really happy to have this opportunity. I think it's a really important topic. So what we would do is, Yuki, if you can put up my presentation on. So the presentation or the flow of this session is divided into two sections. The first part where we would sort of introduce the basic concepts and largely sort of talking about why should businesses care, or why should banks or investors or any other financial institutions care about human rights. But then also the second part of the presentation or the session would focus on how can they do that? So I think what we're trying to do in this session is talk about, why, but then also how and what they need to do as well. Next slide, please. Okay, so, so what happened, it was in 2000, and I think there has been lots of conversations in the past about the responsibility of the private sector and sort of corporates overall to respect human rights. But it was in 2011 that the UN Human Rights Council unanimously endorsed the UN Guiding Principles on Business and Human Rights. Now, the guiding principles are, provide a very helpful blueprint for companies, and companies could be all kinds of companies interested in identifying their human rights risk and impacts and reducing the risk of contributing to human rights violation. So what are these UN guiding principles? The UN Guiding Principles on Business and Human Rights, they implement the Protect, Respect, and Remedy framework that we would come to in the next slide. These are essentially a set of 31 principles directed at states as well as companies that clarify their duties and responsibilities to protect and respect human rights in the context of business activity and to ensure access to an effective remedy for individuals and groups affected by such activities. The particular strength of the guiding principles lies in the fact that they are the result of 6 years of robust multi-stakeholder consultations engaging an unprecedented variety of actors on business, from the business community, as well as civil society organizations, employers and workers organizations, UN member states, and international organizations. The UNGPs apply to all businesses and all human rights, and that's the first point on why should banks even focus on UN guiding principles or look at the human rights impacts. Next slide, please. In this slide, we would introduce the UN guiding principles on business and human rights. The 3 pillars of the UN guiding principles. So essentially what it says that the states have a duty to protect, businesses have a responsibility to respect, and in case there are human rights abuses or violations, they should ensure access to remedy, and that's that both state and businesses needs to do. Now, as I said, the pillar 1 talks about the state duty to protect. It's essentially protection against human rights abuses against actors, including businesses. And Yuki just talked about the National Action Plan, but in Asia, you see now there are many states that are in the process of developing national action plans on business and human rights, which is their first step to also set expectations from the businesses on what they need to do to respect human rights. And then the second pillar, which talks about the business responsibility to respect, and it's the UN guiding principles expect the businesses not to respect human rights only in their own operations, but also through their value chains. And that's one of the key important points that, in the next few minutes, we would talk about what does it mean and why value chains are so important to businesses, and therefore managing the human rights risk and impacts in the value chains for businesses. It asks for businesses to act with due diligence and also address adverse impact. The third pillar, as I said, focuses on access to remedy, and remedies could come in the form of judicial remedies as well as non-judicial, both state-based and non-state-based judicial remedies. Next slide, please. Today, we would focus on pillar 2, which is essentially on the business responsibility to respect. So let's try and understand what do we really mean by this corporate responsibility to respect. The guiding principle says that all business enterprises have a responsibility to respect all internationally recognized human rights. As I said, this pillar 2 is from 11 to principle 24. It defines the nature of the responsibility and prescribe ways to discharge it. So essentially, pillar 2 expect the businesses to do no harm, but also when there is a harm, should address the adverse human rights impact. That's a responsibility that the UN guiding principles expect from the businesses. Next slide, please. So the guiding principle, as I said, is the pillar 2 range from the guiding principle 11 to 24, and I think the key here is principle 13, but then also sort of looking at principle 65, principle 17 to 21 that talks about human rights due diligence as well as access to remedy. According to principle 13, the corporates may create human rights impacts in different ways. They may cause, contribute, or be directly linked to such risk. We will talk about this very specifically in the next slide because it has really direct implications on the banks or the financial institutions in general. They're also expected to declare a policy commitment to respect human rights. That's essentially your principle 15A to 16. They're expected to conduct human rights due diligence, which is essentially the process. How do you respect human rights across your operations and supply chains? And businesses are expected to put in place process to enable remediation of any adverse human rights impact. That's principle 15C to 22. Next slide, please. So this is guiding principle 13 that talks about that the businesses should avoid causing or contributing to adverse human rights impacts through their own activities, as well as address such impacts when they occur. They should also seek to prevent or mitigate adverse human rights impacts that are directly linked to their operations, products, or services by their business relationships, even if they have not contributed to those impacts. Next slide, please. Now, what does the guiding principle means for, what does the guiding principle 13 means for banks or financial institution? As you've seen from the previous slide, it distinguishes between, when a bank can cause, contribute, or has a direct linkage. Let's dwell further on what do we mean by that. A bank can cause an adverse human rights impact where its activities, now these activities could be both actions as well as omissions, on their own, remove or reduce a person or group of persons' ability to enjoy a human rights. That is, where the bank's activities alone, without those of client or other stakeholders, is sufficient to result in an adverse impact. Now, whether the bank's actions and decisions on their own were sufficient to result in an adverse human rights impacts without the contribution of the clients or other entities. So that's where, and this is largely, this is largely would happen in particular in terms of causing, the situations are most likely to arise in the context of a bank's own employees. For example, if a bank discriminates against women or racial minorities in hiring practices. So this is what the bank is doing within their own operations largely. Contribute. A bank can contribute to an adverse impact through its own activities, either directly alongside other entities or through some outside entity such as client. Contribution implies an element of causality. For example, if the bank's actions and decisions influence the client in such a way as to make adverse human rights impact more likely. Now, whether the bank was incentivizing harm, that is, whether the bank's actions or omissions fail or even if its failure to act will cause the harm. Now, such instances are necessarily instances of contribution. For example, a bank that provides financing to a client for an infrastructure project that entails clear risk of forced displacements may be considered to have facilitated and thus contributed to any displacement that occur if the bank knew or should have known that risk of displacement were present, yet it took no steps to get its client to prevent or mitigate that. In principle or in practice, actually, many of these impacts associated with the bank's financial products and services may fall into the category of direct linkage. Direct linkage is a situation where bank has not caused or contributed to an adverse human rights impact, but nevertheless, there is a direct link between the operations, products, or services of the bank and adverse human rights impact to the bank's business relationship. A situation of, whether the bank was facilitating, this kind of particularly talks about whether the bank was facilitating the harm. That is, whether the bank adds to the condition that makes it possible for someone else to cause harm. It may facilitate a client or any other entity, or it may facilitate a client or any other entity to cause harm if it knows or should have known that there is a human rights risk associated with, a particular client or a project, but it omits to take any action to require, encourage, or support the client to prevent or mitigate these risks. There is an OHCHR guidance on banks, and I think we could circulate that as one of the references to look at further. But the guidance also note that there is in practice a continuum between contributing to and having a direct link to an adverse human rights impact, and that a bank's involvement with an impact may shift over time. It could shift in either direction, depending on its own actions and omissions. For example, a bank may move from being directly linked to an impact to contributing if it fails over time to take reasonable steps to seek or prevent or mitigate an impact which it is made aware of. The guidance also provides further context and explanations for each of the different points that we discussed just now. And I would strongly encourage, and I would also strongly encourage all of you to read that. Now, can we move to the next slide, please? Okay, let's now, let's kind of talk about what are the different kinds of human rights that the banks could impact, but then also look at what are the top human rights risks that the banks or the financial institutions may have. The bank may discriminate in lending practices. What does it mean? The lending practices may deny customers access to finance based on race, religion, or gender. Loans are now increasingly approved or denied by algorithms. financial models have the potential to perpetuate, exacerbate, or mask discrimination. So that's something that, banks kind of need to sort of start looking at, particularly in the context of, particularly in the context of their, lending practices. So that's one point to look at. The banks, one of the other human rights risk is also, when banks needs to do or conduct a customer due diligence. All financial institutions, large or small, should engage in environmental, social, and governance due diligence before issuing loans. Lending to customers without first examining their social and environmental records may result in facilitation of gross human rights violations. This may manifest as financing governments that abuse their citizens or accelerating the growth of a company that exploits its workers. So it could have impact, if you have not done your customer due diligence, it could have an impact both in the context of how governments are operating, but then also how companies may exploit their workers. When banks are lending, it's also important to conduct a sector due diligence because, the business and the human rights issues across there are human rights impacts of all sectors and all industries. However, there are a few sectors that are more likely to have very distinguished and unique impacts on the communities and on the people, and I think that's where it's really important to look at the sector due diligence. Business should consider operation of specific impacts, such as a mining project. The mining project does have a potential of displacing local residents, but then also geographic context in which the investment take place. The potential impacts of failing to conduct sector due diligence are wide-ranging. It could also impact your environment or the environment, largely looking at the environment in which these operations take place. Corruption is pervasive in large-scale projects that seeks outside funding, especially those taking place in autocratic countries, carried out by state-owned enterprises or overseen by politically connected individuals. Banks should definitely look into this because also corruption and bribery profoundly affect vulnerable communities, either by misdirecting funds that could be spent on healthcare, education, or other public goods, or by preventing participation in the democratic processes. Moving on to the next, looking at the large-scale infrastructure and land development projects. Now, these are the projects that require robust due diligence on issues involving land rights, displacement, forced relocations, particularly in countries where access to remedy of these violations is curtailed or non-existent. And we've seen during the times of COVID, also in the name of making business, getting the economy to thrive again, how many of these projects or many of the countries have weakened their laws protecting environmental rights. Trading and investment in commodities, particularly staple foods or other agricultural products, can distractly affect the price of food, water, and healthcare, and therefore could restrict land use or other natural resources for vulnerable populations. While these impacts may at first glance appears to be beyond the scope of financial sector due diligence, the distorting effects of commodity purchases can be profound. So that's where banks need to sort of assess and understand their, particularly the trading and investment in commodities, because that does have an impact on the basic rights, your food, shelter, your healthcare as well. Data breaches and misuse of customer-employee information may result in human rights violations, particularly if sensitive financial information is disclosed. Companies or the banks must ensure that all collected data is protected through regular security upgrades and adequate employee training. Moving on next, one of the other impacts that we see, or one of the top human rights risks that we see, is in supply chains and modern slavery. All businesses that procure products or services that are at a risk of contributing to forced labor and human trafficking in their supply chains, regardless of the scope of regardless of the scope of a company's procurement, it is crucial to conduct a supply chain mapping to identify the greatest risk, investigate compliance with local laws, and wherever possible, also remediate violation. While a company cannot be responsible for all the working conditions in all the suppliers, it is important to identify the most severe violations and take actions to prevent them. And it is when financial institutions lend these companies and these businesses, that's where the responsibility also lies with the banks to see whether they are incentivizing harm by providing those resources that helps them that kind of helps increase the risk to the communities and people. The banks could also, and then, in addition to all of these different issues that we talked about, land rights, displacement, forced labor, access to basic facilities such as food, shelter, water, access to vaccines, livelihood, access to health and safety conditions, and climate change and environment. There's, the banks at an overall level could end up discriminating, within their own operations, but then also sort of through the supply chains. Beyond the gender, if you sort of bring in sort of the gender dimensions, and look at the gender guidance to the United Nations guiding principles, you also see that beyond the gender wage gap, financial institutions have also discriminated against other minority groups in hiring, promotion, and workplace and cultural practices. While significant strides have been made to address these issues, especially sort of in the developed market, it still remains a significant concern. So banks should address these issues directly through policies, procedures, and trainings related to workplace discrimination and sexual harassment, and should monitor and engage their workforce to prevent discriminatory practices. And with that, and with this slide, I think we've come to sort of an end to the first section of our presentation, which sort of focused largely in terms of why should banks care, and what are the different human rights impacts that the banks may have.
Thank you, Harpreet. So we will, as Harpreet said, we'll take a little bit of a pause here before Harpreet continues her slides, and we take a Q&A from yourselves. So I have the first question already, Harpreet. It says, if a bank is truly unaware of a possible impact, is it still considered to be complicit to the issue based on direct linkage clause?
We would kind of, I'm glad you're asking this question, because that kind of also is a great segue to our next part in terms of, how should banks conduct human rights due diligence? Even if the question really is, why should bank not be aware of it when, and it's the responsibility of the bank to make sure that the money that they're lending is, could have potential human rights risk. Now, what happens is, at the time of, and that's where, we would talk in the next slide about human rights due diligence. For example, at a time when when the bank provided the loan, there may not be human rights impact, or at least, at that point of time. But in your due diligence, it is really important at that particular point of time to see not just what are the current human rights impacts, if the bank lends, but then also look at what could be the potential human rights impacts in the coming days. That's one. Secondly, human rights due diligence is not a one-time process. It should be an ongoing process. So, what banks need to do is to continuously sort of monitor, continuously conduct due diligence, and then I'm saying human rights due diligence, and not just due diligence kind of looking at what are the risks to the bank, because would banks stop conducting due diligence in an ongoing manner to see what could be the impacts on their own operations, or sort of within their own circle? So it's really important that human rights due diligence is equally a part of your due diligence processes, and looking at impacts that may have over a period of time as well. Thanks.
Okay, so to summarize what you are saying, ignorance is not a justification, and that we need to assess this as on an ongoing basis, and that it's an evolving and continuous process. Okay, maybe we encourage other participants to also pose their question on the Q&A. But while we are waiting, maybe just one more question from my side. So on the last slide that you showed, there was a lot of things that banks and investors need to consider in human rights. What is the resources that are available that you would recommend that financial institutions go? At UNEP Finance Initiative, we do have the toolkit on human rights for financial institutions, And I would recommend banks and investors looking at that as well. It does talk about sectorial issues, about these different human rights issues that were presented by Harpreet. And it also looks at the industries that are especially at high risk of human rights. So looking at the agriculture and fisheries and utilities and so forth. So I would recommend that as one of the resources. Harpreet, would you have any other good resources that the banks and
Sure. One of the key resources that you could have is, look at the OHCHR's guidance for the banks. And this was specifically also in response to a group of banks, who actually asked what does UNGPs have to do with banks and, what steps they need to take. So I would say, the starting point would be the OHCHR guidance. Then also look at bank track. They're kind of looking at, you could go to the website and you can look at in terms of what all is going on, but also be able to follow the discourse on UNGPs and banks and, where you see in terms of the new developments. And I think particularly in the context of mandatory human rights due diligence and the global growing, the global tide in terms of mandatory human rights due diligence. So I think definitely bank, bank track is another good resource, and you would find tools in there. BSR has also introduced some tools, so it would be good to look at their toolkits and would be good to look at what, how they have identified the top 10 human rights risks. In fact, the presentation, the previous slide was inspired by looking at a lot of material from the BSR as well. Another source would be, there is this website called Business and Human Rights Resource Center. So go to businesshumanrights.org. And, you could actually select by sectors. You could also actually, the other advantage that I would say, at the Business and Human Rights Resource Center website is that you could actually find information on, I think they now track about 8,000 companies worldwide. So if you go to the website and, just click on the company's name, you would actually be able to see what have been what has been the human rights record of that particular company. So I think that is a great source, just in terms of your own due diligence, looking at, how are these companies being perceived? What are the impacts these companies already making on the ground? And I think also just in terms of, and again, on the Resource Center's website, you would also look at the sectors. So, you can also look at, for example, if you're lending in for a mining project or, for a big power project, you could actually go to the website and find out what kind of human rights impacts should be there. So, it's also kind of answers to the first question in terms of what if bank doesn't know? I mean, and that's how bank, needs to conduct that due diligence process before they lend. Thanks. And we can send these resources. I would just, try and put it in the chat box or
yeah, that would be super. Yeah, thanks very much for introducing all these resources. Yeah, so there was actually a question saying, could you share with us the websites of these resources, please? Yeah,
sure, I will.
You can add it in the chat box.
Sure, in a bit when we finish the session, I'll type in there. If there are no more questions, Yuki, should we go on? And
yes.
I realize I just have about 9 minutes now.
It's 10:06 and you have until 10:30, so okay, we have enough time.
We've got enough time. Thanks.
So we'll start sharing your slide, and then there is another opportunity for Q&A after Harpreet finishes her presentation. So please do put your questions in the Q&A box while she is presenting. Thank you. Please go ahead, Harpreet.
Can you go to the next slide, please? So I think in the first section, we largely talked about why should banks care? What are the different potential human rights impacts that the banks may have? I think this section of the presentation talks about how should banks do that, or looking at the human rights due diligence process that the banks should adopt. Now, this is a human rights due diligence process. So in line with the UN guiding principles, banks should have in place a policy statement on human rights, clearly communicating their human rights expectations to clients and other business partners. and a due diligence process to identify and assess impacts, drawing on both relevant internal and external expertise and in consultation with the stakeholders. Integrating the findings from their impact assessment across relevant functions and departments, and also track and account for how impacts are addressed. Now, in order to satisfy itself that its financial products and services are not being used in ways that can cause adverse human rights impacts, a bank should clearly communicate its expectations to its clients and undertake human rights due diligence appropriate to the proposed transaction, which may include seeking assurances from the client that it has in place adequate processes and systems and policies to identify, prevent, and mitigate risk associated with its activities. So this is not just looking at your bank and your own self, but then also understanding what are the systems that your clients have in terms of both policies as well as processes to conduct their own due diligence and their impact on an ongoing basis. For example, a bank may be one of the several financiers to a project where a client, in breach of agreed standard and the client's own policies, violate health and safety regulations in a way that put workers' health at a risk. In this case, the bank has not contributed to the adverse impact. However, once it's made aware of the situation, they have to take steps in there. A review should also be undertaken of how the bank's existing due diligence procedure measures against the guiding principles. All banks will have different governance systems, and it will be helpful to identify where the guiding principles fit best from a due diligence oversight and cultural perspective. Now, once banks have this, policy commitment, and we just talked about identifying and assessing impact, when we're looking at sort of really assessing and identifying and assessing impacts, we should also make sure that, we're also kind of looking at that once you have identified those impacts, you also integrate and act upon those findings. Now, the UN guiding principles do not ask banks to duplicate the existing system. It's like there are systems that are already available and very effective. So there's no need to kind of duplicate the existing system. And especially when it's likely to be most effective, if they're adapted to include the human rights due diligence process. There are established tools and resources that are available through existing initiatives. Of course, the Equator Principles, UNFI, UN Global Compact, Oecd. And these are some of the helpful ways where we can look at how to conduct human rights due diligence to deal with the conflicting human rights or issues where the right way forward is not clear. Also it's important that once you've integrated the findings and you've acted upon the findings, you also go ahead and then you track and monitor, and that's where it brings into this is not just one-time process where once you have identified and assessed the impact, say at the beginning, and then you forget about it. It is an ongoing process, because also especially for the large infrastructural sort of land development or development projects, the impacts start to appear, when the work starts on the ground. So, it's also, and that's why it's really important that you continue to sort of have it on an ongoing basis. And therefore, it is a process of continuous improvement and not just one time, not just kind of one time and looking at your annual report or reporting, for your reporting purposes. I think also communicating and reporting is equally important. Once you have identified impacts, you communicate clearly, you integrate and act upon the findings, and you're tracking and monitoring. But it is also important to communicate, both to your internal and external stakeholders, or what it is, but then also reporting on an ongoing basis. And there are different mechanisms where you could also be reporting on this one. And now I think we would go on to sort of the next process, which is essentially, and I think this kind of pretty much sums up your due diligence process in terms of what are the different steps. But perhaps we would need sort of like a dedicated session on human rights due diligence when perhaps in the coming days. But really looking at, I think that's where your due diligence process, these steps kind of helps you identify your human rights impacts on an ongoing basis, but also ensuring that once you have identified these impacts, there are systems, there are policies, and there are processes for also remediation, and we will talk about remediation in a bit. But I think from here, let's go on to the From here, let's also sort of go on to the next slide, which focuses on policy commitments. Okay, what needs to be done for a policy commitment? As I said, this really is the first step, where the banks, and that's true actually for all kinds of businesses, but, since we're talking in particularly in the context of the banks, I think we would sort of, give an example, I try and sort of bring an example that's helpful for this. But essentially, this is a statement of this, the banks should come up with the statement of policy and governance framework that should be developed, which aims to express the bank's commitment to respect human rights. Now, it's really important that this is a process, or this is, that this comes from the leadership, or, the tone from the top, as we say, is important in gaining buy-in from other parts of the organizations when making explicit reference to human rights and range of policies, and integrating a human rights perspective in decisions and processes. What also happens is a lot of times these specific policies, their understanding, the knowledge about these policies and potential impacts just remains isolated in certain sections and, in certain functions of the banks, and that shouldn't happen. And that's why, as a first step, it's important, may be helpful to identify relevant internal stakeholders and understand the external relationships the bank maintains, which may provide sector-specific information. Now, and I think that's where it's important that if you do have a commitment from the leadership, it trickles down. It trickles down to the bottom, and that's where it's important that you bring the leadership on board, and the policy should have leadership's approval, and the leadership should be involved and engaged in in an ongoing basis. I think this next step of the policy commitment is also making sure that it's comprehensive and inclusive. There is that it's comprehensive, but then also there is an inclusive implementation. Now, as we said, all the banks do have due diligence processes, and you may not be calling them specific, human rights due diligence process, but a lot of these due diligence processes looks into the human rights impacts as well. So what the UNGPs are saying is it does not require banks to create new systems all the time. So, also conduct a review of what are your existing due diligence processes and procedures and policies related, and where do you identify human rights risk and issues within there. So it's also about building on what that's already available. And therefore important to generate that, and therefore, that brings me to the point on consistencies, be embedded in already established procedures and proactively communicated in dialogue with employees, your clients, your business partners, investors, suppliers, and other stakeholders. Once we've developed the policy, it's equally important to have an inclusive implementation that requires, creating awareness, building capacity on the importance of human rights issues to business decisions, including the focus on doing no harm and impact of getting it wrong. But at the same time, once it's done, how do you help remediation? That would be equally important to look at your, when you're conducting trainings and awareness programs. The last one is, in terms of the policy commitment, there should be accountability, and it should also be reviewed on an ongoing basis. You could, for example, start with a policy, a policy for 3 years or 5 years, but then also identify people, also identify clear accountability and allocation of responsibility, monitoring and reporting requirements, and escalation procedures, in case you identify there are gaps. Or for evaluating risk or dilemmas as they arise. Again, as the due diligence process be subject to review, regular review, audit and consultation, and sign off via a high-level governance process. What banks may also do is, in terms of looking at the resources that could help them in developing these policies, is one, to conduct a mapping to also understand what are the current levels of awareness and understanding of their employees, within the organization, and who are the people who understand this. So also bringing in both internal as well as external stakeholders. Also, as I said, you also may need to sort of look at what are the existing resources that are available. And again, just kind of reiterate, there are Equator Principles Association, Geneva Finance Initiative, IFC, OECD guidelines. There are also independent consultant and industry trade associations, such as the International Council for Mining and Metals. And then And then you can also look at the other banks, maybe peer banks, development banks, how they are doing this, the export credit, the export credit associations, legal advisors and clients who may be familiar with dealing with human rights issues. So it's really important from an engagement perspective that you identify and build relationship with departments and managements who may contribute usefully to the management of human rights issues. Again, as I said, these may include teams with responsibility for credit risk policy, for transaction level risk assessment, project finance, investment banking client relationship teams, but then also looking at your compliance, legal policy, public policy, corporate responsibility, internal and external communications and others. So what I'm trying to say is, do not develop a policy in isolation. Identify your units, your people, your functions within your organization, within your bank, who could potentially contribute to assessing human rights impact. But then also make sure that there are provisions for building capacity of the bank itself, and there are, as I said, there are existing resources that are available to be able to do this. Can we move to the next slide, please? Can we move to the next slide, please? Okay. Now, once you have conducted human rights due diligence, the next step really is sort of looking at the remediation. The UNGP 22 stipulates that where businesses, enterprises identify that they have caused or contributed to adverse impacts, they should provide for corporate in the remediation process to legitimate processes. Now, the application of UNGP 22 is limited to situations where a bank itself, recognizes that it has caused or contributed to an adverse impact. A bank may arrive at such recognition through its own due diligence process in consultation with stakeholders or through other operational level grievance mechanism. And we will talk about operational level grievance mechanisms in a bit. The commentary also makes clear that remediation requires active engagement by the bank, meaning that they should actively seek to ensure that timely and effective remedy is provided. Now, remedies can take a variety of forms, and it is important to understand what those affected would view as an effective remedy. So do not, as Professor Surya, who's a member of UN, who's now, I think, the vice chair of the UN Working Group on Business and Human Rights, often says, you have to look at remedy in the context of a bouquet of remedies and looking at, what is that the people or in the affected communities want. It's not, do not decide what is remedy just by yourself. So in addition to banks' own, view, you also need to look at, what does remedy mean for the people who are impacted. It may include an apology, provision to ensure the harm cannot recur, compensation, both financial as well as other, for the harm, restitution, rehabilitation, cessation of a particular activity or relationship, or some other form of remedy as agreed by the party. So it could. So, it could kind of take different forms and different, it could sort of then take different forms in terms of what the remedy could be. Now, we did talk about active engagement. What does active engagement means? It implies that the bank should continue to closely follow the situation, even where remediation is not being provided by the bank itself. And take appropriate actions when needed to ensure that remedy is indeed being provided. So while even in the situation or circumstances where the bank is not providing remedy itself, and but it must actively stay engaged also with the client or client, which could also be a business, to kind of look at how are they facilitating access to effective remedy for those who have, whose rights have been abused and violated. Now, the UNGP 22 does not prescribe that the banks must provide the remedy directly through its own mechanism. So we are not asking, or the UNGPs are not asking the banks to do it just by, by themselves. In both cases, the affected stakeholders and the bank may prefer a legitimate external grievance mechanisms to hear the case and decide on remedy, but the banks must remain actively engaged through the process. Moving on. Can go to the next slide, please. Okay, now And I think that brings us to the next point on leverage. If a bank has identified adverse human rights impacts directly linked to its financial products, its services, its operations through a client, it is not responsible for providing remedy. However, there are still actions expected of the bank other than remediation, that is to seek and prevent or mitigate the impact. Now, the banks should also look at their, the banks should also sort of use their leverage in ensuring that the client or the products or the services that they're providing through their clients are taking cognizance of the human rights impacts that they are that they have in terms of both on communities as well as environments in the same way. Now, the UNGP 19 and its commentary makes clear that the appropriate action will vary according to the extent of the leverage that the bank has in addressing the adverse impact. However, the expectation is that it will take steps to seek to do so using its own leverage. This is, this is separate from the substantive responsibility for remediation for identified harm, which is sort of set out in UNGP 22. Now, look at the operation. I think the next where, we're looking at in terms of particularly in terms of providing access to remedy, we're looking at operational level grievance mechanisms. While operational level grievance mechanisms may be established in response to specific situations of of adverse impact, the UNGP's intent for them to be established proactively in order to provide a venue for stakeholders to raise concern and resolve them before they escalate to large-scale grievances. So what banks must do is also set up the operational level grievance mechanisms proactively, even before before any human rights concerns are being raised. And this is essentially that comes from UNGP 29 that stipulates that companies establish or cooperate in grievance mechanisms in order to make it possible for business enterprises to address grievances early and directly. In other words, banks are expected to have mechanisms in place, their own or one that they participate in, to respond effectively if or when grievances arise. Now, what does it mean? It means that the UNGPs do not require every bank to have its own operational level grievance mechanisms. You could participate in mechanisms that may be established in collaboration with other entities, for example, through industry-wide networks, through multi-stakeholder initiatives or sector-based human rights initiatives. So in addition, the UNGPs make it very clear that the operational level grievance mechanism should form one form of a broader system of effective remedy mechanisms, which could include your state-based as well as non-state-based, both judicial and non-judicial mechanisms as well. While operational level grievance mechanisms are one means through which remediation can be provided, some impact may be remediated best through legitimate mechanisms, and that's why saying it's the bouquet of remedies should be such that it provides options to choose from. It provides alternatives to also sort of understand what could be effective for what could be an effective remedy for for the affected communities. I think largely the banks should respect stakeholder preference with respect to use of operational level grievance mechanisms or other legitimate processes and engage with the latter in good faith. And that kind of sort of brings us to the end of the presentation in terms of how do you look at remediation. And I see there are a few questions in the Q&A. Yeah. So yeah.
Yes, thank you, Harpreet. Yeah, there is a comment in the chat box. If participants can use the question and answer box, that would be better, but I'll address that one first. So I think the question in the chat box was about the remedy period. Is there an end point, an end time on these issues?
So your remedy process could not be lifelong. As we say, excess justice delayed is justice denied. So just to kind of put in that sort of a jargon here, but really looking at what do we mean by access to effective remedy? And I think the operational word is effective here. And the UNGPs identified these specific criteria for your remedies to be effective, and timeliness is one of the key elements in there. Where there is looking the ease of accessibility, affordability, but then also looking at the ease of and as well as the timeline of the remedy. I mean, what's the point of providing a remedy that goes beyond people's life. And, we've seen in the cases, particularly in the cases, where there were fires or any, or any accidents, and, there, and then you continue to see these examples where compensation are not being paid generation after generation. And, the case in point is I was speaking to somebody about the Bhopal gas tragedy of 1984 in India. It's 1984 and the victims are still seeking compensation, sort of 3 decades later. So, and I think that's a really good example of, how you need to look at the human rights impacts, not just in the current context, because, this was essentially a chemical leak. And the chemical leak could have impact, it did have impact not just on that generation or people who were there, but then also through their future generations. And I think that's where it's not easy to provide remedy, right? Because, you also need to, how do you assess, especially if it comes in the form of financial compensation, how do you assess the cost of somebody's life? But I think that's where, you bring in different stakeholders. You use the existing mechanisms or the resources that are available, including the multi-stakeholder initiatives, as well as industry associations, to assess, to take steps together in terms of how do you identify these, both financial and non-financial compensation processes or procedures. Thanks.
Okay, wonderful. So I think we are at the end of Harpreet, our time with Harpreet. And thank you very much, Harpreet, again for joining on your busy day. And we look forward to getting in touch again in another opportunity. Thank you, Harpreet.
Thanks, Yuki. And I'll just enter a few resources in the chat box and perhaps can send you an email and you can circulate among the participants.
That would be lovely.
Thank you, everyone. Have had these great 2 days. I wish I had time, but really looking forward to tune in to some of these recorded sessions. Thanks and good luck, everyone. Have a good day.
Thank you. Bye-bye. So participants, we will now take a 10-minute comfort break until 10:40 Bangkok time. Please keep yourself logged on and we will resume at 10:40 again. So thank you and stay tuned. Dear participants, welcome back. We will now resume the webinar. So we are now starting a new session called Managing Human Rights Risks for Investors and Banks. In this session, we're very fortunate to welcome 4 distinguished speakers who will talk on the theme of managing human rights risks for investors and banks. In the previous session, we heard that from Dr. Harpreet Kaur talk about what is human rights and why it's important for businesses. In this session, we focus our attention on what actions banks and investors need to take to respect human rights. So this session provides information on the OECD's responsible business conduct standards and the PRI's guidance to investors on human rights, as well as practical experiences by a banker and an investor. So the first speaker is Ms. Barbara Bijelic, legal expert at the Responsible Business Conduct Center of the OECD. Barbara leads the OECD's work on responsible business conduct for the financial sector. She works with both investors and banks to implement the recommendations of the OECD guidelines for multinational enterprises. Barbara also leads the OECD's engagement on regulatory initiatives related to environmental and social due diligence. Prior to joining OECD, she worked on governance and private sector growth initiatives in Ethiopia, Cambodia, and the Democratic Republic of Congo. So before I pass the mic to Barbara, let me remind you to please use the Q&A function to raise your questions to Barbara. Barbara will speak for about 15 minutes and we will have a short Q&A after that. So we're very fortunate to have Barbara speak live today. She's joining us not from Paris, where OECD is based, but from the US, where she is temporarily based. So good evening to Barbara, and thank you very much for joining us during your nighttime. We look forward to your presentation. The floor is yours. Thank you.
Thank you, Yuki, and it's a pleasure to be here. So let me just share my screen quickly and put up my presentation. Can you all see that and hear me okay?
Yes, we are able to.
The silence.
Yeah, we're seeing your
screen. Perfect, perfect. Great.
So thank you for the great introduction. As Yuki mentioned, my name is Barbara Bijelic. I'm a legal expert with the OECD, and I'm based in the Responsible Business Conduct Center of the OECD. Before sort of getting into OECD standards on due diligence for the financial sector, I wanted to just quickly give a little bit of background on the OECD guidelines for multinational enterprises. At the RBC Center where I work, our primary objective is really promoting and implementing this instrument. And this is probably the most comprehensive instrument on responsible business conduct that's in existence today. It covers human rights issues, and in that respect is actually aligned with UNDP recommendations for corporations, but it also goes beyond that to look at other substantive areas, including labor issues, environment, corruption and anti-bribery, taxation, competition, and the like. 50 governments have adhered to this instrument, which means they have committed to actually promoting and implementing these recommendations amongst businesses that operate in or from their territories. And these governments represent OECD members, about 37 members, as well as now 13 non-member adherents, and they cover the vast range of global business operations and supply chains. One thing that is unique about this instrument is that's equipped with a government non-judicial grievance mechanism known as the national contact points. So governments that adhere to this instrument also commit to establishing an agency within their countries to both promote these expectations, but then also to handle any complaints related to corporate misconduct under any of these chapters. And so they've handled over 500 cases involving various issues around the world. The guidelines were first introduced in 1976, but were last updated in 2011, which was the same year the UNGPs were introduced. And that's when they incorporated the expectation of responsible business conduct due diligence, which aligns with that of the UNGPs. And I'll talk about that in a little more detail in this presentation. So as mentioned, the guidelines, they align really word for word with the recommendations of the UNGPs in the context of our human rights chapter, but also the ILO Tripartite Declaration for multinational enterprises. And we really see them as an important tool also for driving the Sustainable Development Goals, because they help businesses identify their priority issues and give them the framework to respond to those issues in a sort of systemic way that prioritizes ongoing continuous improvement versus disengagement. So moving to the financial sector, we actually published a publication this past year, our Business and Finance Outlook, which is our flagship publication in the Directorate for Financial Enterprise Affairs, that focus on sustainable and resilient finance and sort of the trends, drivers, challenges, opportunities that we're seeing in this sector across these issues. We contributed, the RBC Center contributed a chapter on banking specifically, and we've identified 3 broad drivers for responsible business conduct in the banking sector. The first is increasing expectations and demand from investors. We know that responsible investment is a huge and growing industry. Currently about $30 trillion in assets under management is in responsible or ESG driven funds. That is expected to grow by some estimates to over 50 trillion in the next decade. So it's a growing sector, and as a result, investors are asking of banks, but also issuers, to think about these issues more carefully and disclose of them more carefully. For this publication, we interviewed the 20 biggest banks operating in OECD countries, and all of them told us that pressure from investors and growing investor expectations on ESG was probably the main driving force in them taking action to enhance their own ESG processes. And S&P also published a similar study interviewing about 200 credit practitioners, where 97% of them noted that investor demand is sort of what is driving this change. So this is relevant for banks not only that are publicly traded, but also banks that provide underwriting services and issue bonds, as of course there's a market for this, and this type of information is becoming increasingly important. The second big driver we're seeing for RBC in the banking sector is increased expectations from civil society and advocacy groups, and society more broadly, I would say even. So we know that advocacy campaigns targeting the financial sector have doubled in the past couple of years. In the context of our own non-judicial grievance mechanism, the national contact points, we've seen also cases involving financial institutions double over the past 5-year period, and it's currently one of the most prevalent sectors in terms of complaints that we get. Definitely the introduction of the UNGPs and the increased expectations under the guidelines regarding due diligence have contributed to driving this. But I think a lot of these groups are trying to consider and explore what this really means for the banking sector and to push expectations forward on banking practitioners. One of the main issues of debate and discussion we've seen in the past years is this discussion of to what extent should banks be considered to be contributing to impacts when they finance clients or projects that then cause human rights impacts or environmental impacts. And in those instances, to what extent should they be responsible for actually providing remedy for those impacts? This is a controversial issue. We've sort of answered the question a little bit. I know OECD has also been looking at this issue in detail. And actually in one of our national contact point cases, which was followed up on last year, we saw for the first time an example where a bank, in this case ANZ Bank, actually provided compensation to local communities in Cambodia that were harmed by a project it was financing involving a palm oil plantation. So very interesting progress there. The third big driver we're seeing is regulatory expectations and initiatives related to RBC in the financial sector. So broadly, there's been a lot more regulatory attention paid to institutional investors, but this is also growing for banks and lending practices. I won't have time to go into detail, but I just wanted to flag maybe two big initiatives that are happening at the level of the EU that might also impact practitioners in Asia and also issuers based in Asia that rely on international investment. The first is that today, actually, as of March 2021, the EU regulation on sustainable disclosures for investors has gone into effect. This regulation was the second, I think, legislative initiative that was approved in the EU Sustainable Finance Initiative last year. And it calls on asset managers to identify and disclose environmental and social risks and impacts across their portfolios. So as of March, now all asset managers in Europe will have to comply with this, and they'll have to report not only on their financially material environmental and social impacts, but also those impacts that are environmentally and socially material that actually cause harm to communities and the planet. The second regulatory development I want to highlight is the introduction of mandatory due diligence rules that are currently under discussion also at the level of the EU. So the EU Parliament, but also now the Commission and Council have all formally voiced support for the introduction of mandatory due diligence rules, which will be modeled after OECD due diligence guidance and the UNGPs, and which will apply across sectors. So they're not specific to garment sector or minerals, but they'll be applicable to all sectors, likely companies over a certain size, including the financial sector currently, so including investors and banks in Europe. Of course, this is still under discussion. There hasn't been any sort of final legislative ruling. We likely won't be able to expect anything for 2022. But once this is introduced, this will become an important standard of conduct for managing environmental and social risks amongst corporates broadly, but also the financial sector in Europe. So getting now to the OECD standards on RBC for the financial sector. In 2014, we launched work around RBC for the financial sector. And the objective of this work was really to explain what the recommendations of the OECD guidelines meant for institutional investors, banks, and other types of financial service practitioners, but then also to define what due diligence practices should look like in the context of specific transactions. In 2017, we published a paper on RBC for institutional investors, and in 2019 on due diligence for corporate lending and securities underwriting. And right now we're finalizing what will be probably our last guidance in this series for now, specific to project and trade finance transactions. These papers are developed over a pretty long period of time in really close consultation with a multi-stakeholder advisory group, which comprises leading practitioners, but also policymakers, civil society, and other experts to ensure that they're both practical and realistic, but also ambitious. And then they also have to go through an approval process in our committees. So these guidances are actually backed by 50 governments as best practice for these types of transactions. And by the way, I shared a link to this in the chat earlier during the first presentation. So I think that we already had a very good introduction actually to what due diligence means in the first presentation. So that makes my job a little bit easier. The one thing I want to highlight is that this terminology is used pretty differently under the guidelines and UNGPs than it is in the financial sector. In the financial sector, it's generally understood as a process that's conducted prior to an investment being made or financing being extended to identify risks and liabilities. But under the guidelines and UNGPs, it's a much more comprehensive process. It's not just about identifying impacts, in an ex-ante manner, but then taking actions to prevent, mitigate them, further monitor them, and then eventually potentially remediate them if necessary. And as mentioned, this happens on an ongoing basis, and there's an expectation that practitioners also report on the effectiveness of these processes and make adjustments as necessary as part of their core business decision-making and risk management systems. This is sort of laid out in the 6 steps of the due diligence process. Maybe I'll give just very quickly some examples of how we see these different steps being played out in the context of banking and lending transactions specifically. The first step, which is sort of core to the due diligence process, embedding RBC into policies and management systems. This means having a policy in place that outlines a bank's commitments to human rights and other ESG issues, but then also making sure that all the relevant units within the bank are implementing that commitment, so that this isn't just delegated to a sustainability team, but that actually that boards and senior management also understand these objectives and help drive them, that deal teams and business development officers are doing this as well, and that this is part of compliance risk systems, and that there's functional alignment across all those roles. Identification assessment means screening any transaction or new clients for these types of risks, and where necessary, doing more in-depth assessments, for example, through potentially reviewing environmental impact assessments or engaging with management on specific issues. Seize, prevent, and mitigate in the context of lending transactions. It can mean a lot of things. Most importantly, it will be before loans are actually dispersed, because that's where a bank's leverage is greatest. So this might mean communicating expectations to clients and making sure they understand them, including those where possible in covenants to make them legal expectations, and also ensuring that clients are able to actually meet the commitments of a bank, and whether or not that they have a plan in place for remediating any impacts. But it does also mean that when impacts do arise, that the bank supports clients in addressing them. So that can mean through providing access to financing, through training, through capacity building, or other efforts. Tracking means just monitoring the effectiveness of due diligence processes, both at a client level, but also at a banking level. Communicating refers to publicly reporting on how sustainability policies are implemented, and due diligence practices are also implemented, and the results of those. And lastly, remediation is important where negative impacts do occur. And in some instances, this may mean a bank would also be responsible for compensating those impacts where it may have contributed to them. We recommend under our guidance that financial institutions set up their own grievance mechanisms, in addition to having clients establish legitimate ones. But this can also happen through industry associations or participation in broader initiatives. It doesn't have to be at the level of every single institution. So I think this goes without saying, but another kind of unique aspect of our due diligence process is that we're focused, when we talk about risk, we're really focused on impact to people and society. So human rights, corruption, environmental issues. These things can also have, and often do have, or come with financial risk, but how that is sort of measured and assessed for us should be done through the lens of what is most severe and likely for people and the environment versus what is most potentially severe for a company in the context of financial risk. I think I'm almost getting to time, so I would just maybe close on this slide just to say, I think a lot of these practices in the lending sector we see are really in early days. So as I mentioned, we did research on this for a publication that was released last year, where we interviewed banks and also looked at sort of practices across the world. We see while there's a lot of ambition to do more on ESG management and due diligence, banks currently are sort of still exploring and learning about this. So in the context of policies and management systems, most banks we spoke to still have pretty small teams looking at this. In some cases, just 2 people with sort of the maximum of 10 to 13, and that's for global banks with thousands of investments all around the world. But there is ambition to scale and also to integrate this across processes, as I mentioned. For identification assessment, this is still very much often limited to just project finance transactions. A lot of banks are EP signatories, particularly OECD banks. So there's an obligation to look at specific project finance transactions for these issues. But when it comes to general corporate loans, this is far less common. So according to the banks that we spoke to, out of thousands of loans that they disperse annually, probably only 10 are subject to enhanced assessment on ESG issues, which is just a drop in the bucket. We also know that banks are not so far very actively or disclosing on ESG risks and how those are managed. Those disclosure practices are below average for other industries. Currently, only less than half banks surveyed, I think in a study done by KPMG, disclosed on their ESG impacts, and less than a quarter explained how those are linked to financial impacts. And lastly, the practice of providing for remediation is also still very new, I think, and very complicated for banks. So thinking about even establishing remediation mechanisms or grievance mechanisms at the level of financial institutions is still something that's just really only recently been discussed. And we have a few examples of where this has been done, a lot of good examples in the context of development finance institutions. But for private institutions, it's very rare and sort of in early days and seeing what works best. I'll end it there, and I apologize I won't be able to stay because it's a little bit late here, but my contact information is there and I'm very happy to take any questions. Thank you.
Thank you, Barbara. And I especially thought that what was really useful is your clarification of the terminology between what banks traditionally view as due diligence and what the responsible business standard of OECD talks about in its circle of due diligence. I think that contrast was really useful. Thank you. So unfortunately, Barbara's time is up, and thank you again, Barbara, for joining us today. Have a good evening. Thank you. And let me now move on and introduce our next speaker, Mr. Matthew McAdam, Director of the Asia Pacific at the PRI, the Principles for Responsible Investment. So Matthew joined the PRI in 2012 and is responsible for overseeing the PRI's activities across the region. Matthew is also a steering committee member of the Australian Sustainable Finance Initiative, ASFI, and he has previously worked at Standards & Poor's, managing communication and media relations, and as a finance journalist at the Australian Financial Review. So Matthew joins us from Australia. Thank you, Matthew, for speaking with us today. And the mic is yours.
Thanks very much, Yuki, and good morning and good afternoon, everyone. It's great to be with you. Hopefully you can hear me okay.
Yes, we can hear you.
Terrific. Let me just load up my slides and we can get going. Okay. Okay, so I think it's fair to say that some of our signatories have been looking at human rights for a number of years, but a majority have not. And at the PRI, we really want to see this change. So last year, we launched a comprehensive new framework to help investors integrate human rights into their investment activities. And this is going to be the focus for us at the PRI for at least the next 3 years. And our aim is that, like with climate change, in 5 years' time, we'll see all of our signatories globally incorporating human rights issues into their investment activities in a much more meaningful way than they are today. So for those of you that aren't familiar with the PRI, I'll touch on who we are and why I exist first. It's important to be clear, of course, about what we mean by human rights from an investor perspective. So I will cover this also, and then we'll look at how investors can respect human rights and how the PRI is going to be supporting institutional investors to do that over the coming years. So the PRI was formed in early 2005 when the then Secretary General of the United Nations, Kofi Annan, invited a group of the world's largest institutional investors to begin a process to draft the 6 principles for responsible investment, which were then subsequently launched in 2006 in New York. The PRI is fairly unique in that it's an investor-driven, investor-led initiative. We benefit from the ongoing support of the United Nations to put the 6 principles into practice with investors. And they've really remained unchanged since 2010, which gives investors real continuity over time. And the 2 UN partners that we work with are UNFI and the UN Global Compact. Overall, our goal at the PRI is to help create a more sustainable financial system and to help investors achieve this by incorporating ESG factors into their portfolios and decision-making process, which we think is not just, is not just the right thing to do, but in a way that makes sense for the investment community. And we do this within the context of investor duties, and particularly an investor's fiduciary duty to manage risk and return over the longer term. We now have well over 3,000 signatories signed up to the PRI, and that includes over 500 in Asia Pacific. It's our fastest growing region. And we have 2 signatories there in Thailand, including the Government Pension Fund. So the principles that I mentioned are on the slide here. Hopefully you can see those. Our mission says that we will achieve a more sustainable financial system by encouraging investors to adopt the principles, to foster good governance, integrity and accountability, and to address obstacles that lie within market practices, structures and regulations. These are the statements that our signatories sign up to help us deliver through their investment activities. And what all of this basically means, when you break it down, is that the finance and the investment industry must play a critical role in financing sustainable development and ensure that people's fundamental dignity and rights are upheld. Whether it's a climate emergency, economic or wealth inequality, a call for following the pandemic to build back better. There's a deep rethink going on at the moment in the role that investors play and how they should be conducting their economic activities and investing. And people and human rights in particular need to be front and center. So the idea of human rights is simple but powerful. That is that people have a universal right to be treated with dignity. Every individual is entitled to this without discrimination. And human rights are interrelated, they're interdependent, and they're indivisible. Businesses' responsibility to respect human rights is based on international recognized human rights frameworks, as we've already heard from previous speakers. At a minimum, we understand those to be expressed in the International Bill of Human Rights and the International Labour Organization's Declaration on Fundamental Principles and Rights at Work and the 8 core conventions. So at the PRI, we've made it clear that any responsible investor should build their approach to addressing the social factors in ESG on respect for human rights. And that idea rests on the recognized standards and ideals which essentially codify social sustainability. And while the world around us changes, these aspirations should remain constant. A few examples, I think, that illustrate what issues we're talking about from an investor's perspective would include things like health and safety in the workplace, as well as in a company's own operations and its supply chains, the rights of workers to organize, very important in the technology sector at the moment, equal pay for work of equal value, the provision of a living wage, the avoidance of the use of child labour and forced or bonded labour, the prevention of discrimination, be it based on race, religion, gender, sexual orientation, or any other characteristic, particularly in the workplace, the right to privacy and freedom from hate speech as stressed by digital platforms, the right to property and the security of the person from land grabs and abuses by security personnel, and the right to water and sanitation, which might be undermined by the consumption or environmental degradation caused by a business's production facilities. Since the adoption of the UN Guiding Principles and the OECD guidelines in 2011, we've seen an uptake in human rights norms by a range of stakeholders. Some examples from around the world would include modern slavery acts, which have been introduced here in Australia, in California, and in the US, the Dutch Child Labour Due Diligence Act, the French Duty of Vigilance Law, and EU-wide due diligence regimes for human rights and environmental issues that are currently under consideration. In this region, Thailand's obviously a very early leader, which is terrific to see when it comes to this issue with the publication of the National Action Plan on Business and Human Rights 2 years ago. More recently, Japan has followed in Thailand's footsteps and published its own action plan. And here in Australia, we have a Modern Slavery Act, which is now in full effect. So human rights is definitely an issue that is becoming more salient for investors in this part of the world, and something that they simply can't ignore. Looking at the investment industry in particular, the guiding principles have been used by investors in their engagements with companies for many years, but they can also inform the responsible investment approaches more broadly. But for PRI signatories in most jurisdictions to date, this has been a voluntary exercise, and we've only seen a relatively small number of investors participate or report on human rights, their human rights approaches. In the past 5 years, we've had over 110 investors that collectively manage $13 trillion engage with 100 companies through some of the collaborative engagements that the PRI has been running on human rights. And these are designed to improve corporate practices or disclosure on human rights. And they've used the UN Guiding Principles as the reference point. We've had more than 180 signatories apply to their investment portfolios various forms of screening that reference the UN Guiding Principles. We've also got things like the Corporate Human Rights Benchmark, which is an investor and civil society-led initiative which assesses the human rights performance of more than 200 of the world's largest publicly listed companies. And finally, there is an investor call at the moment for governments to legislate on mandatory due diligence for companies, which is led by the Investor Alliance for Human Rights, which is supported by over 100 investors also. So there is definitely momentum there, and it's increasing. For those of you that are familiar with the PRI, we also have a reporting framework that all of our signatories are required to report each year to outline how they're thinking about implementing the 6 principles. And the data from this exercise tells us that about 40% of our signatories mention human rights at least once in their reporting. But overall, while there's momentum building, there's clearly a very long way to go. So last year we published a human rights position paper, really to start sensitizing or resensitizing investors to this issue and what they can do. It builds on the UN Guiding Principles and the OECD guidelines and makes it crystal clear, we think, that institutional investors are expected to respect human rights across all of their investments. So informed by the Guiding Principles and the OECD guidelines, we think institutional investors have a 3-part responsibility when it comes to human rights. First, they need to establish a policy commitment. Now, we recommend that investors establish this commitment, and that it's approved at the most senior level of the organization and covers the entire organization, and that it's properly resourced. This is a commitment that we think should be integrated into the organization's governance frameworks, into the management systems, if for an investor, into investment beliefs and investment policy and investment strategy to be made very explicit, and also into the stewardship activities with investee companies. Second, we like to ask investors to have adequate due diligence processes in place. So the actual management of actual or potential negative human rights outcomes needs to be reflected in investors' investment decision-making processes, portfolio construction, security selection, and asset allocation, as well as when they're selecting, appointing, and monitoring their external managers and service providers if they're an asset owner. And third, we think investors should be enabling or providing access to remedy. Now, we think investors are responsible for providing access to remedy for people affected by their investment decisions when the investor is either contributing to or causing the negative outcomes as they relate to human rights. And to effectively implement a due diligence framework and access to remedy requirements, we think there are three different levers that investors can use. First, through their investment decisions. So they could use human rights as a deciding factor when they make capital allocation decisions. Well-run companies, for example, that manage human rights issues might find it easier to access financing or even experience a reduction in their cost of capital over time. Second is stewardship. So we expect investors to address human rights issues in their dialogue with investee companies. And third is engagement on public policy. To understand their exposures and the actions required, investors need to ask for information, for better information than they're asking for today, throughout the investment value chain. That means from their investment managers, from their service providers, or from other co-investors. And investors clearly set expectations and have the ability to influence others to know, to act on, and to show how they manage harm to people arising from their business relationships and activities. As I said, the position paper on human rights we published in the second half of last year, and we're in the process of building out a multi-year agenda for our work with investors on this topic. There's going to be 5 priority areas, which you can see on the slide. First, investor practices. We need to get much more practical in aligning investment activities with the guiding principles, in particular across different types of investment strategies, asset classes, and instruments. We know that some of our signatories are working quite hard on this at the moment, but we really need to mainstream good approaches across the signatory base. Second, public policy. We can support the creation of a level playing field through mandatory due diligence legislation and accountability mechanisms. An example would be modern slavery acts, which are being introduced in several markets. The EU is currently leading the way on this, but global consistency and alignment for organizations that invest internationally is obviously key here. So companies and investors can play a very important role, we think, in giving policymakers the right signals and confidence to act. Third is data on social issues, and we hear a lot from investors about the challenge of finding the right data when it comes to social issues, human rights issues, and making sure that it's accurate and comparable across all of the assets in their portfolio. So we need to define appropriate approaches and metrics to capture when companies are actually responding and preventing harm to people and when they're not. So really this kind of is about the need to move beyond policy and process and tick box measurements and capture the real outcomes for people through the investment process. Fourth is investor reporting, and Barbara touched on this with the banking sector, but we need to ensure accountability in the investment industry, of course, as part of this process as well. And on that note, we are adding some additional human rights indicators into our own signatory reporting framework next year. First, this will be voluntary for investors to complete, but over time, we intend to make this mandatory. And we're also looking at the possibility of introducing some minimum requirements for investors when it comes to human rights in order for them to become a signatory or to maintain their signatory status. There would be some kind of minimum standard that they would have to demonstrate on human rights, as we recently introduced for other issues. And finally, on stewardship, the guiding principles really need to be at the heart of conversations between investors and companies to drive action that is much more forward-looking and preventative, and replace the current thinking and approaches which are largely, we think, reactive and narrow and compliance-driven. So finally, we have already developed a range of investor resources and tools and guidance on human rights, with a lot more to come over the coming years. The resources that we have so far outline that the starting point for respecting human rights and labour rights is really to understand the impact of a company's activities on people. They clarify that human rights violations and child labour in supply chains can expose companies, can and do expose companies and investors to material regulatory, operational, reputational risks, which can impact company share value, which can negatively impact operations and production capacity, and can lead to strikes and disruptions. But they also highlight that finance is a real lever that can move the entire economy. The finance sector obviously has really unparalleled influence over global business, and it can invest in and foster business practices that can help to end modern slavery or human trafficking, or it can serve to perpetuate them, to further them. So we want to recognise that for investors as well, the just transition is another area where the just transition provides a framework for connecting climate action with inclusive growth and sustainable development for all. So that brings me to the end of my prepared remarks. I can't see any questions in the Q&A box, so I might hand back to you, Yuki.
Thank you, Matthew. We did actually have one question, a generic question on the PRI. It says to sign up to the PRI, is it as an institution, or can investment instruments sign up to the PRI?
You do have to sign up to the PRI at an organizational level. You can't just sign up individual funds or instruments. So hopefully that answers that question.
Yeah. Okay, thank you, Matthew. And for me, what was really interesting is the development of human rights disclosure within the PRI's signatory requirement. I think that really shows how the issue is becoming salient within the industry globally. So very much hope that the Thai investors also join the PRI and actively, get support from your organization and to further develop their capacities around human rights. So thank you very much, Matthew. And unfortunately, our time with Matthew is up. So thanks very much for joining us. And we will now move on to our next speaker. So our next speaker is a well-known, long-time active member of the UNDP's community. She's Ms. Rosemary Bessette. Rosemary is the head of sustainability governance and risk at the National Australia Bank. She has responsibility for the integration of ESG risks into the NAB Group's risk management framework, and for ESG related disclosures, such as those relating to human rights, climate change, and natural capital. Rosemary is also a director of North East Water and the Business Council for Sustainable Development Australia. Rosemary is also joining us from Australia. Thanks, Rosemary, for speaking today. And the mic is yours.
Thank you, Yuki. Hello, everybody. I look forward to sharing with you briefly today. And I think, Yuki, you're going to share the slides for people.
Yes, can you see it on your side? We are now sharing the screen on our side.
Yes, I can see it now. Thank you. That's great.
Okay.
So I'm going to give a nod every now and again to Yuki so that we can change slides. So I would like to talk to you really and provide a case study on how NAB as a bank has implemented human rights risk management in our ESG risk framework and into the wider bank. So if we go to the next slide, we'll cover off sort of where at the highest point we start to bring human rights thinking into our ESG risk management framework, how that is considered as part of the risk management process because it is like every other risk, touch on our human rights policy, which is part of our implementation, our approach to managing modern slavery, as you heard from Matt, in Australia and in the UK, there are now modern slavery disclosure acts. The disclosure under those acts require you to manage modern slavery risk. So essentially that is what we're doing. And so I'll talk a little bit about that. That is an example of human rights risk management in action, and briefly touch too on Equator Principles and the fact that that has now integrated even more strongly in Equator Principles version 4 human rights considerations. And then we can go to Q&A. So the next slide. So right at as part of our risk management strategy and framework, we've developed a set of ESG principles, and they speak to environmental, social, and governance responsibility. I won't go through them in detail, but essentially there are 2 social responsibility principles. One is around making sure we encourage diversity and support and respect the protection of internationally proclaimed human rights and labour standards. The other social responsibility principle is related to the products we provide. So, and the products that our customers may provide as well. So human rights is embedded in those principles, and that is embedded in these principles are embedded and referenced in our risk management strategy and framework. So material risk owners, your traditional owners of risk like credit, operational risk, market risk, they're expected through the way we integrate this into the risk management framework to establish appetite, processes and controls. So the traditional management tools of risk within a financial institution to oversee and monitor and report on ESG risks, which includes human rights. And we recognise that ESG performance of ourselves, of our suppliers and of our customers can give rise to ESG risks, including human rights related risks, and that may impact on credit risk, particularly if we're lending, or other risk categories, and by association, the bank's reputation. Last year, at the end of the year for this year's risk appetite statement, sustainability risk was actually included as a material risk category along credit, operational risk, etc. We go to the next slide. Great. So here you see the key elements of the risk management process. And it starts with us being informed. And you heard Barbara speak about the OECD guidelines. So up the top, you can see the OECD guidelines, the guiding principles for business and human rights, the Universal Declaration of Human Rights, and then there's additional guidance that's coming out as different regulatory requirements emerge, like the Australian Commonwealth Modern Slavery Act. And there's similar guidance in the UK. All of this is informing what we do. And then that is going into our normal process of setting risk appetite and policy. In our case, we have a set of industry sectors that we highlight have specific ESG risks. It doesn't mean that we won't necessarily bank them, but it means that we need to be alert to whether they're higher risk and they might sit outside our risk appetite. So we're defining and including our appetite towards human rights violations and modern slavery in our risk appetite statement. Then the front line, or line one, our customer-facing divisions need to manage risk. It is part of their day-to-day job. And so we're building it into the tools and frameworks and the due diligence processes that are used as part of either get to know your customer, the KYC processes, or as part of internal annual review of clients. Then we're monitoring and reporting on that. And we're also reviewing, as part of managing risk, the controls we have in place. So more recently, we've set up obligations for internal customer divisions related to managing modern slavery risk, and they have to make sure they've got controls in place to manage those risks. And we get back to the end of the cycle where we review risk appetite, policy and processes on a regular basis. So it's built into the risk management framework, like any other risk. If we go to the next slide. I just thought it was worth showing you the information sources and the places we go to learn about something like human rights risk. It can be peer financial institution or bank, in our case, policy and experience, regulators, information from government and policy makers, academics, NGOs. They're particularly valuable. Our human rights policy, which is on the next slide, if we go there, is something that we review annually. It's approved by our board, and we consult with a range of NGOs on an annual basis as we are reviewing this policy, and they gave us a significant and valuable input when we formed the human rights policy. And we put the policy in place. It sits as an overarching or umbrella policy for a whole range of human resources or credit or supplier management policies, which all have aspects of human rights risk management in them. And it actually indicates that NAB's human rights policy covers both the legal and regulatory obligations, as well as our voluntary commitments. Like, we have committed to uphold the Universal Declaration of Human Rights, the guiding principles on business and human rights. We're UN Global Compact signatories, and that also requires us to uphold human rights. We're principles for responsible banking signatories, and they again require us to uphold human rights. So our human rights policy is bringing that collective and the OECD guidelines, all those commitments that contain human rights aspects together are covered in our policy so that we can make sure our systems and processes and all our broader set of policies, like our diversity and inclusion policy, our anti-discrimination policies in the people area, those sorts of things are covering the various aspects of human rights. We recognise that human rights concerns not only arise in our business, but in our suppliers and our customers' businesses and through our business relationships. So the policy is speaking to all of those things. And we're committed to upholding and respecting human rights in our interactions with our people, our customers, the communities we operate in, and through the suppliers. And that's through how we work. It's part of our values. And I've mentioned the range of things that NAB's made commitments to do that incorporate human rights. The policy itself, as well as including sort of overarching statements and commitments, it covers how we respect the human rights of our people, how we respect the human rights of our business in our business relationships, so customers, joint ventures, suppliers. It sets a framework for due diligence, monitoring and review, for training and communication of our people, for stakeholder engagement, grievance and remedy, and for reporting and disclosure on human rights. And for the last 3 years, we've included in our annual risk awareness training that all staff participate in. We've included a module on ESG risk, which includes in particular a module which picks up on human rights and modern slavery. And that is so all of our people actually understand what that looks like because of our regulatory obligations. If we go to the next slide. And part of what we're doing in the credit side and procurement side of things is thinking about when we do identify through our ESG risk processing credit, and that exists not just for project finance, and Barbara mentioned sometimes the ESG processes can be limited to project finance. Ours aren't. They extend to our whole corporate and institutional bank and our business bank. So if a banker, through the ESG process, identifies human rights impact or modern slavery risk, then we actually assessing that in terms of, have we caused it, have we contributed to it, or are we directly linked to it through our customers? And then we're using this framework which was set out in the Liechtenstein Initiative's FAST implementation toolkit to help us decide on what action we will take. If it was a customer, potential new customer, was causing human rights impact, that may then mean because of our risk appetite that we might say no. If it was an existing customer, then we'll be talking about whether they can prevent or mitigate it, the risk to our satisfaction, or whether we need to get to a point where we make a decision on exiting a customer. If we go to the next slide. This is to just give you a little bit more detail around modern slavery. And if you haven't come across it before, practices that constitute modern slavery include things like human trafficking, slavery or servitude, forced and compulsory labour, debt bondage, forced marriage, and the worst forms of child labour. So we're building tools and systems now to help our bankers and our financial crime teams be able to identify where there's risk of NAB product or services being used, because often modern slavery is linked to people who are engaged in financial crime. So our financial crime investigations team is absolutely investigating instances where staff may be suspicious of having a customer having links to modern slavery or financial crime. So you can see there, it can include situations where people are forced to work through coercion, where they're essentially owned or controlled by an employer and often threatened. Like there's been instances even in Australia where people have had their passports taken away, or they've been threatened with reporting to somebody and being deported by an employer, so that people are scared to actually say, excuse me, I'm a victim of modern slavery. It could be that they are dehumanized and actually treated as property, or that they're constrained. And you even see that sometimes in domestic help situations where somebody has actually been trapped almost in the home as a domestic slave. It happens in rare instances in Australia, but it can still happen. If we go to the next slide. Here are some examples. We use the what's called the Modern Slavery Index, the Global Slavery Index. This is from the 2018 version. It's a useful tool. It highlights the countries with the highest likelihood of or prevalence of modern slavery. And you can see the rankings of a few different countries like Australia, New Zealand, China, Japan, Indonesia. And it establishes that ranking based on the estimated number of victims. And we've looked in particular at countries where we operate to see what the likelihood of modern slavery is. But when we're looking at procurement, absolutely we're interested in the supply chain and which countries the supply chains of our suppliers may go into, whether they're countries with high prevalence of modern slavery and whether they're in sectors where modern slavery can occur too. So it's a combination of sector and country risk that we're considering, and that drives and triggers the due diligence process. Go to the next slide, please. You can see here the requirements of the acts that we're subject to at the moment, the UK Modern Slavery Act and the Australian Modern Slavery Act. In Australia, New South Wales, which is one of the states of Australia, is considering an act, but it hasn't been proclaimed yet. So at the moment, we're subject to 2. And essentially, they're transparency requirements. They require you to disclose certain things if your annual turnover or consolidated revenue is over a certain trigger threshold. They're extraterritorial. So if one part of the group is in, all parts of the group are in. So when we triggered the UK Modern Slavery Act in 2016, globally that meant we had to comply. Same with the Australian Modern Slavery Act. They have different requirements on where you have to publish, but essentially you have to publish a modern slavery statement which describes your structure and operations and your due diligence and remediation processes and policies related to managing modern slavery and human trafficking. And how you've got to describe how you assess and manage that risk. Now, the legal requirement is a disclosure requirement, but to be able to disclose, you actually have to do. So it is actually driving changes in risk management practices for financial institutions and corporates who are triggering the Act. And we also, in the Australian Act, it's a mandatory, we talk about how effective our systems are for managing that risk too. So we have to talk about the control effectiveness of our risk management systems. And performance indicators for any data, and we also have to provide an explanation or some discussion around the training that we're giving our people to recognise what modern slavery looks like. If we go to the next slide. So this, as Matt said, is making a big difference in the maturity of companies in dealing with an example of human rights risk, which is modern slavery. Here, this slide is just showing the different possible exposure points that you could have and that you need to look at if you're tackling something like modern slavery risk as an element of human rights risk. So your operations, customer relationships. If you've got stock holdings, then you're looking at your investments. You need to look at complaint and feedback processes. If you're in wealth management, advisor and broker services, and in the supply chain, suppliers and other third parties where you may have business relationships. If we go to the next slide. So we're trying to think about all those things. This slide just gives a few of the highlights of what we've done in terms of modern slavery risk. So that has been incorporated into our human rights policy and our group procurement policies. It's included, as I said, in risk awareness training. There's been special training for our Know Your Customer and financial crime due diligence teams. And our financial crime major investigations team has developed an investigations guide and typologies for recognising modern slavery. We have a system here reporting to our regulator for financial crime when it's detected, and essentially bankers are encouraged, if they see something that looks suspicious and it might involve modern slavery or financial crime, then they will raise an unusual activity report or a UAR, and that goes through to the investigations team. And then if they actually investigate and find that there is something that needs to be reported to the regulator, then they will report on to the regulator. We also have incorporated modern slavery into our whistleblower program so people can report it and that they're protected when they do that. It is part of our risk management processes to identify, assess, mitigate and monitor potential risk in areas like sourcing and lending activities. So we have checklists in lending that include modern slavery. And then in procurement, taken action to purchase responsible products. So we're buying fair trade, tea, coffee, sugar and putting them in our kitchens for people to make tea and coffee. We're making sure our corporate clothing doesn't include modern slavery by looking at, who's providing those services and what their practices are. And we've checked that thoroughly in the print and promotional goods and services area as well. And we're participating in industry working groups like the Responsible Investment Association in Australia, like the UN Global Compact Australia, the Australian Banking Association. I should have put Principles for Responsible Banking on there as well. And that engagement with the sector is also key to helping us get new ideas and ways of improving our risk management. And we publish our modern slavery statements as well. If we go to the next slide. The other thing I was just going to cover is the Equator Principles briefly. Now, this is for lending. It's an environmental and social framework for lending, risk management framework. Lending that applies to projects, so corporate finance, project finance. Now it's extending to acquisition finance and refinancing. And within the Equator Principles, version 4 now strengthens the expectations for management of human rights, and it requires a human rights risk assessment where those risks, so you can understand whether those risks are high or not. And essentially it's giving effect to the guiding principles requirement that financial institutions should respect human rights. The other thing that it's done is increase the focus on making sure that our clients have good engagement with Indigenous communities, and that where Indigenous communities are involved and impacted, that there is a process for free, prior and informed consent. And that's looking at the requirements of the International Finance Corporation's Performance Standard 7. Now, if we go to the next slide, the Equator Principles has a kind of two-step process for that human rights risk assessment. Step 1 is to answer the series of questions you can see there around how serious the impacts could be for a victim, how many people might be affected by the harm, whether there's the ability to provide remedy to restore the victim to the same or equivalent before any potential harm, and what's the likelihood of that impact occurring. And then essentially you're looking at when you've done that assessment, is it a low risk? And then is the risk mitigation employed by the client satisfactory, or is it higher risk and you're going to require that the client actually does a lot more work, that they need to do further assessments, further engagement with the communities, and that will actually prompt more in-depth review of documentation and engagement between the bank and the client as well. So that's just kind of giving you a high-level flavour for that. If we go to the next slide, and there is a growing number of resources on modern slavery. And you can see some of the ones relevant particularly to investors that have been produced by the Australian Council for Superannuation Investors, through the Responsible Investment Association and the ethical, I think it's the Ethical Banking Initiative. No, Ethical Trading Initiative. So there's some really good guidance out there, and we've taken a lot of ideas from a range of those pieces of guidance as we've developed our own policies and processes. And I think that is my last slide. So if you go to the next one, Yuki, thank you all, and I'm happy to take any questions.
Thank you very much, Rosemary. Just a quick question from my side. So when you say financial crime, is that referring to money laundering, and that they are using, like human traffickers are using your accounts and banking system? Yeah.
Yeah. So essentially it's part of the normal bank processes to identify financial crime activity. A lot of modern slavery is connected to financial crime activity. So essentially in detecting one, you can identify the other at times.
Okay, great. Thank you, Rosemary. So unfortunately, our time with you is up, but thanks very much for joining us today, and hope to see you again soon. Thank you.
Thank you.
Okay, so we are going on to the last but no means the least speaker for this section of the webinar, and we are with Mr. Jadeep Singh Panwar of the APG Asset Management. Jadeep is part of the APG Asset Management's Global Responsible Investment and Governance team. He is responsible for researching engaging and guiding the integration of governance and sustainability in public equities across Southern global emerging markets and some developed markets, including engagements with key regulators. Prior responsibilities at APG included ESG integration across real estate and infrastructure assets classes. Jadeep joins us from Hong Kong, and we are changing the format of this session with Jadeep. Instead of a presentation, I will be doing an interview with him. So dear participants, please do use the Q&A box to participate in the interview with Jadeep. Thank you, Jadeep, for joining and speaking today. Maybe as an opening question, would you briefly tell us about APG Asset Management's approach to ESG and where human rights fit into this? Thank you.
Thank you, Yuki. And once again, thanks for having APG on this. I think, you know, as a preface to that, it's helpful to also know APG and its clients. APG manages assets for Dutch pension funds. So in a sense, our clients have similar sets of values and a thinking process, and also exist in a similar or the same regulatory framework, and sort of are answerable to societal expectations that are quite common. And what that does for an asset manager such as ourselves is that it allows us to have an approach to ESG that is very coherent to what our client requirements are. And with that said, I think, you know, ESG has therefore been something that we've been able to take on quite early, because some of this thinking around, you know, long-term responsibilities, long-term consequences of, you know, ESG-related aspects, whether it's climate or something else, was something that when you've got these long-term liabilities, you can sort of, you know, start thinking about that and putting that into your frameworks. So the point there being that ESG had come in quite early in terms of APG's context, and it also then synced in with the values of clients. And then when we speak about values of clients, human rights is really an underpinning factor in there. Now, you know, given that we are a global asset manager, managing across global assets and multiple strategies and multiple asset classes, you know, I would say ESG integration applies, you know, we use a wide range of methods, and that would be from the most basic exclusion approach, which is to say that, look, if these entities, whether it's companies or certain markets, do not meet minimum standards for us, these are entities that we would not invest in. But that's not a primary approach primary method that we use. The others would be, say, thematic engagements. So certain themes that we think are particularly key from an ESG point of view in particular major sectors that we need to sort of focus on, we would sort of take on multiple year engagement programs with them to try and improve the companies that we're invested in. In addition to this, you have an inclusion approach, which has been there since now 2016, which says to all the companies that are in your, thousands of companies in your portfolio, that if you are in a particular sector and given your sort of emerging market or developed market context, we would expect you to meet these standards on particular sector-specific aspects. And many of these would also include human rights. And if you don't, we have to engage with you to either get you to a point where we think we're comfortable, or at a certain period of time, over a period of typically around 2 years, but it can be a little bit plus minus, then we'd have to take a call to say this is something that we would not invest in. But it's a systematic approach that's taken across the portfolio. Of course, some differences depending on asset class to asset class. But our clients have a very clear underpinning of this, is that you may engage in whatever theme and other things. Corporate governance on one side is a sort of fundamental framework, and the other part is human rights. And I can sort of talk to you about some examples as well as to how we work on with human rights. And I would sort of emphasize in a human rights concept, context, the way we would sort of pick it up typically is, one, if you are a market that's sanctioned by the EU or the UN on certain criteria, maybe we'd have concerns about having exposure to that. And that's one approach. The other approach would also be, as I spoke about in terms of inclusion, if you are in a higher risk market and you don't have, you know, human rights standards and practices that meet what we think are higher expectations, then again, it would be a challenge. But let's, you know, speak about the specifics in terms of examples, you know, in the next parts.
Okay, thank you. So, yeah, let's talk about the specific parts then, because I think that's really interesting. And what you've said so far is how long-term engagement is really important in your due diligence and human rights and ESG processes overall. So let me share a slide that frames this question, because it is a little bit complicated. And it's about if you can share your experiences in implementing APG Asset Management's human rights policies in ASEAN. Now, I think, let me break this question up into different situations, because Jadeep, you know, there are things that happen in ASEAN that is in the context of adhering to local and regional legislations and growing expectation among society. But then there are also adhering, even though things are happening in ASEAN, it's also about adhering to foreign, for example, the EU standards as part of the supply chain. And then lastly, in a totally different context, managing human rights that is happening outside of ASEAN, within the global supply chain that the ASEAN customers or your investees are purchasing from, and how much should companies know where their supplies are coming from. So if you can touch on these different aspects to enlighten us, that would be great. Thank you.
Sure. So, you know, speaking about ASEAN, again, if I step back from, you know, looking at the last 10 plus years, you have to keep in mind also understanding the ESG landscape among investors. ESG is not new, but if you have a global emerging market portfolio, or you have a global portfolio, ASEAN tends to be a, you know, relatively smaller part of the overall mix, or has been in the past. And if you then split into individual markets, again, you know, it becomes a smaller. But in that, I think Thailand is clearly one of the bigger ones. Now, what has happened, and this is changing, and I'll talk about, you know, what are the implications of it changing as well, is that by and large, and I'm generalizing, the previous or the extant ESG folks who have sort of worked in this area, whether it's portfolio managers or ESG specialists, would come around, say, once in a year to the ASEAN markets, talk with their various companies, look at these various issues, and sort of make some adjustments around there. Now, I think the major issues to me from a human rights perspective in the ASEAN region that came through in this last decade were, one is clearly palm oil. And palm oil is not necessarily a very Thai-specific issue, but it is a regional, you know, issue, where, again, given where they were supplying to, a large part of these companies were sort of going and supplying to eventually global MNCs. The attention that was paid to on this, because of their MNC exposure, brought the spotlight on the local providers that were either Singapore-based or Indonesia-based or Malaysia-based, you know, and then that put pressure on investors to ask questions and increase scrutiny. You know, so there was this whole range of approaches. What had happened in this space, I think, over the last 4 to 5 years, because of softer commodity prices, or soft commodity prices, there was a certain amount of, you know, attention that sort of got lowered. But this is an area in which the markets, the companies, some of the investors, also some of the local investors have tried to sort of come up with an approach related to RSP or something else to say what could be global standards that allow us to integrate. The other areas to me that come to, or sort of the bigger events are, of course, in Thailand, what you had with the seafood supply chain. And that again came through, and the pressures really came through because of, you know, partly these modern slavery sort of conditions we talked about previously, but also because of questions that were asked of the buyers of these companies that there were exposures to. And then you had, both the Thai government, some of the companies, the buyers on the other side come together to say, okay, let's, improve standards. I think the challenges in both these sectors, whether it's palm oil or in seafood, especially where you're offshore, is that the supply chain is so diverse and very hard to track that it, I think, will still have certain challenges and something that we sort of need to watch for. The other factor in the ASEAN sort of context has been more recently, from 2018 to now, have been with the glove makers, where you have, particularly the focus currently is on Malaysia, but you also have glove makers in Thailand. And part of this is down to, again, the requirements of migrant labor from, one ASEAN market to another ASEAN market. And, this brings me to the point about where the landscape is changing. And I think where the landscape is changing and how you as a Thai investor might need to look at your companies a little bit differently is this. So two things. What I've talked about so far has been, again, driven by some sort of regulation elsewhere, but also demands of MNCs, who are buying from you. But in this glove makers case, what you've had is that the US CBP, so that's basically the Customs Department, because of certain rule changes, has been able to sort of exercise greater sort of oversight and say, well, no, you do not meet these human rights standards that we now have, and therefore you need to sort of match up to them. So in addition to that MNC buyer, you also have what the US CBP could be doing. And this is, remember, they're doing this in the midst of a pandemic, right? So if the US CBP is going to take such an approach, more scrutiny, I think as a Thai investor in Thai companies or companies in the region, you're going to have to sort of take a more watchful approach to say, where else could these issues reside? And where could it start sort of playing up in us as access to markets for these companies that we're invested in? And I think the EU as well will follow on this. So it will not be anymore a game of the MNCs saying this is what we want, but it will also be of the customs departments. And they can take, I think, sometimes a much more stringent approach as well. So that is one thing that you need to watch out for. The second part that you need to watch out for is this, as I said, ESG, for many investors, not everybody, but it could have been like an affair where people would come in, have a conversation, would make a few changes in the portfolio. But I think with the EU SFDR requirements and what could potentially be happening in the US as well, the scrutiny of investors and asset managers is going to only go up. And if you're believing in this, view that you may have a splitting of supply chains globally, and if you want to be seen as a beneficiary of that, but if you then have human rights issues in your particular companies and they have exposure to it, with this added new scrutiny coming both on the customs side and also on the investor side, if I have investments in companies with a decent foreign institutional investor base, and there's a risk then that the foreign institutional investor base will say, over a period of time, I'm not going to be investing in you because you're sort of continue to have these issues, even if you're selling to regional markets. I think then again, as an investor of Thai companies, I need to be watchful of that. And I think I have a couple of points in terms of, how do we sort of work together on that a bit later. But these are rules of the game that I think you have to be watchful for what is changing. And therefore, you could have said, well, these issues existed previously as well. But, this is something that you need to look out for. You asked me this question about global markets more so because we, engage with companies elsewhere as well. Now, I think the supply chain issues linked to human rights are very, very tricky. And say, for example, you've had this, push towards electric vehicles. So basically the centrality of batteries in, say, electronic components. So that's been there for a while. But also now with EVs or with energy storage, and these are key sustainability plays. Back in 2016, I think Amnesty International put out a report saying that, look, 60% of the world's cobalt, and cobalt is a key battery material, comes from the DRC. And in the DRC, in this cobalt mining, you've got a whole range of systematic child labor that goes on, along with a whole string of issues. When we went about speaking with global OEMs in the automotive sector and the electronic sector, we found that most of them said, we don't know, we've been hit by this report as well, but we don't know where, cobalt necessarily comes from in the supply chain, because it's a multiple 7-8 layer supply chain, which is quite complicated. And remember, these are also companies that were hit by 3TG related requirements, and that was Dodd-Frank. So that was tin, tungsten, tantalum, and gold. So there were regulatory requirements. They had to go and look at the supply chain, again, related to some of these issues. But, they were not ready. But in this period of time, in the 4 years, you've had them with much more visibility of the chain, much more responsibility in terms of how they try and influence a chain that's about 6 or 7 tiers further above. But again, the point being that the landscape of your expectations are completely changing. And that's what, as an investor or even a bank is what you need to be watchful for.
Thank you. Thank you, Jadeep. I guess for me, what's quite striking is that in the US customs case, it kind of shows that things can change overnight for investors and clients. Is it that quickly that things can change in ASEAN as well?
So I think in the US customs case, the rule changes happened a few years ago. But, when they come and, decide to strike, certain things have to fall into place when, an action happens, right? So, because what can create complacency is that you see, okay, the rule has changed. Okay, there are, different expectations being set by the market, but this has not meant much. I will put some things together on paper. But then when it starts hurting you, it can come up. So therefore, in our view, we try and be as best prepared as we can be, and understanding the sort of names that we invest. And I think, if you're also referring to what's going on in ASEAN. And I think in the ASEAN markets itself, there is a little bit of competitive intensity that I'm finding over the last 3 odd years, where I think particularly Thailand, Malaysia, Singapore, some of the others as well, are trying to position themselves as, into this, sustainability plays, into ESG, trying to sort of push that through in terms of the market. Initial reaction could be, well, this is something we need to sort of create some paper around. I think that would be a very problematic approach. And if I link it to one other point, which is on climate, right, on coal. Coal financing has been an issue for a long period of time, and I think it still is. But 5 years ago to now, there's been no change in our understanding of climate science and things. That, of course, is incrementally improved, but the urgency of it hasn't changed. I think 5 years ago, if you spoke with a bank and talked about, okay, you're sort of financing coal and things of that sort, you would get a very different response. Today, the sort of pressure that is coming through because of government-related targets and ambitions that are being set, if you took a sort of backseat approach to it, I think you could end up with a portfolio that you don't know whom to now pass it to. So I think in a similar vein, it will not sort of work out exactly the same way. You have to be very watchful of these human rights expectations. And ultimately, it's also, for a good thing, right? So I look at it, both ways fit.
Right. Thank you. So that then brings me to the last question then, about what kind of recommendations and offer you would make to fellow investors in Thailand and in the ASEAN around human rights collaborations.
So I think, this is referring to what I said earlier, and I would really encourage an asset manager sitting in Thailand, or sort of if you're invested in basically your exposure to Thai markets, I would say you'd have a pretty decent focused understanding of the companies, deeper into the markets that, say, a global manager that may invest in the larger names. You have, and you should start assessing your portfolios for, these sorts of various risks identified. Where could they be exposed to potential tightening of customs rules? related to human rights? Where could they be exposed to? So say, for example, if you've got companies with a decent bunch of European managers managing them, and they have some human rights issues, and you know the management has not bothered to sort of move on things in the past. But if the scrutiny is going to increase for the European manager, what then does that mean for their ability to continue to invest in that company? And therefore, what could that mean potentially for, the stock, right? Also things such as, exposure to, certain sorts of activities in, say, other parts of the region which have very high human rights risks. So if you're exposed to certain markets with high or escalating human rights risks, again, will there be implications for other shareholders to be able to own them? And I think, so my reach out to the domestic investors, anybody who's sort of listening in there, is that if you would like to collaborate with a foreign investor, on some of these companies, make the case to them, we would be very happy to do that. You can also reach out through to the PRI because they have groups sort of involved in that. And if you sort of want to sort of work with global, human rights related processes or engagements, there's something called the Corporate Human Rights Benchmark that we've been founding members of. And I think we'd be very happy to sort of welcome you on board. I have a range of other suggestions as well, but I think we are maybe out of time. But, these are some practical steps that I would really encourage you to take because things can be a paper exercise for so long. But at the point, you suddenly have a change in expectations if you, and then you really know who's prepared and who's not prepared. So those are my thoughts for you. And I hope some collaboration comes out of this.
Right. Thanks very much. That's an excellent recommendation and offer, and hope that the participants today will take up on this. So thank you very much, Jadeep, for joining us. And now we will take a lunch break.
Thank you.
Thank you. We will have a lunch break now until 13:13.